Absolutely, Louise.
Brilliant, brilliant. Thanks very much. Well, good afternoon, everybody. I hope you're all keeping well. Going to spend about the next half hour on one of my favourite topics, annual leave. So hopefully we'll cover most of the key topics, hopefully that are raising issues for us at the moment. I suppose certainly in my experience, never before has the issue of directing people to take leave, encouraging people to take leave. It's certainly it's never been an issue that has been as popular or as a priority as it is now. Questions like never before. I suppose as furlough was extended from June into October, our initial concerns about whether it was fair and whether we should encourage and direct that staff take some annual leave whilst they're on furlough, those concerns have given way, I think, to the fact that potentially half of someone's leave year may be spent not working but on furlough leave. And I think as a result of that, we're all, I think, much more comfortable in June than we were maybe in March and April about directing our staff to take some leave if they've not taken some gentle encouragement. And the weather has also certainly helped and the lifting of restrictions. I think the three pieces of government guidance that I've taken off the government website and put on that slide, I think that's really useful, welcome reassurance, I think, from the government. And I'm actually using that detail when I'm preparing emails for clients and things like that, where I think some of the staff who maybe haven't seen a lot of their colleagues or left the house too often, maybe from the end of March, do need to hear it sometimes. And I think this is really useful detail for any sort of communication. We already know, of course, that workers on furlough can take holiday, but very important, employers should do everything reasonably practicable to ensure that the worker is able to take as much of their leave as possible in the year to which it relates. And another key point, workers who are on furlough are unlikely to need to carry forward statutory annual leave, as they will be able to take it during the furlough period. As I'm sure you've been aware, the working time regulations were amended in April, towards the end of April, to ensure that anyone, particularly frontline services, if anybody was unable to use their annual leave because of the issues presented as a result of the pandemic, that they would be able to carry over some of their leave. Now, I suppose key point, it's not all of their leave under the contract of employment, it's their 4-week entitlement under the Working Time Directive. And whilst we understand the logic, and no one would certainly dispute the importance that those who've been working very, very hard may not have the chance to take all of their leave and should be given the chance to retake it or take it again over the course of the next 2 years. I suppose the challenges the government would have faced in applying that only to certain people would have been something employment lawyers would have made a meal of as usual. So it's universally applicable. So employees don't need permission from their employer to carry over their working time directive leave. And I suppose a key theme for me today is that, you know, if we don't help our employees to manage their leave, and if we don't plan ahead, we almost potentially sleepwalk into a situation where staff will come to us at the end of the leave year to say, well, sure, you know, I didn't have time and I didn't think I really wanted to take leave, and you haven't directed me to take any leave, so I'd like to carry over up to 4 weeks, please. And I suppose it's maybe not the top of our list right now, which is why, you know, it's so far away. I suppose the leave year for most people is maybe December or March, but now is definitely a good time to look at it. And there'll be some cases, particularly with the fluctuation in workloads, where we won't be able to allow our staff to take significant weeks off or 2 weeks off, maybe in the autumn, because of catching up on backlogs or increased workloads. So there'll be some cases where quite genuinely we'll be happy for staff to carry over. But I suppose my thoughts today are trying to plan ahead to make sure that we don't accidentally allow a situation to develop where more people are carrying over than perhaps really should be. I think it's always useful, and you'll thank me maybe later when we get into the calculations, but I think it is useful just to set out the legal framework for anyone. It was just to refresh memories about how our annual leave is made up. So every piece of annual leave has 2 or 3 components. The first is your 4 weeks leave entitlement under the Working Time Directive. So every employee has that entitlement. So that's our core chunk of 4 weeks, which is 20 days for a 5-day week worker. On top of that, we have the additional 1.6 weeks or 8 days for a 5-day week worker that was granted by the UK under the Working Time Regulations. And then thirdly, for those who have more than a 28-day annual leave entitlement, there's the third tranche of legal rights, which are the additional rights that are granted or the additional days that are granted under the contract of employment. So those employees who have a total annual leave entitlement of say 30 to 40 days per year when you would include bank holidays, etc., will have 3 strands: the Working Time Directive annual leave, the Working Time Regulations, and the additional leave granted under their contract. And I'm sure you know already that the difference it can mean in terms of how we calculate their holiday pay and their entitlements to carry over often depend on what leave we're talking about. And you'll be familiar with the concept of normal remuneration for the last, I think, 9 years, stretching back to the Williams and British Airways case, I think was 2011, when the European Court of Justice started the wheels rolling in relation to employees being entitled to be paid not just basic pay, but their normal remuneration when they're on leave, and that relates solely to the Working Time Directive leave, which is the 4 weeks at the top point. So as I say, how the leave is made up or its legal background can be very important. And that's again relevant here because when we're thinking about whether we can require an employee to take leave, so if we're going to give them notice that we require them to take a certain number of days or weeks, or we're going to actually cancel pre-arranged leave, which hopefully wouldn't be too often because that can be very upsetting. But the legal basis for that actually sits under the working time legislation. So when you are maybe looking at resources online, sorry, that's my phone. Sorry about that. These things happen. When you look at the notice periods and when you're reading online about the right to require an employee to take notice, I would just bear in mind that those rights relate to the working time rights, so up to 28 days. I'm not sure too many employees are going to make a difference, but it is important to bear in mind that technically those provisions relate to the leave entitlements up to 28 days. You can ask, I suppose, employees, if you were looking to give someone notice, it's twice as long as the length of holiday you're asking them to take. So if they're going to take 1 week's holiday, you need to give them 2 weeks notice. You can ask them you can seek their permission to give them a shorter period of notice. And in fact, I came across many examples of that in and around the Easter time and with the use of furlough and topping up. So I've come across a number of examples of employees who are only too happy to agree to a shorter notice period, and at the end of the day, communication and good interaction can oftentimes mean that we can get these things done. Above and beyond those 5.6 weeks, I suppose I would say look to your terms and conditions or your holiday policy to see what, if anything, your policy provides in relation to giving notice. When we're on that, I suppose I always have a long to-do list that I keep sort of things to do on a rainy day, but it's probably important that coming out of this, that when we do plan ahead to perhaps at some point in the future revise or update our annual leave policies, it would be wise, I think, to make sure that your policy does include a provision that would allow you as the employer to reserve the right to fixed leave dates, so to give notice of fixed leave dates. Not just at the start of the leave year. I see a lot of the wording, I think, just traditionally was crafted along the lines that we let you know at the start of every leave year. Well, I suppose we weren't anticipating too many pandemics, but it has taught us that we need to be flexible. And so if your wording is directed that you'll only tell people at the start of the year, not a bad idea when you get the chance or when the opportunity to review that comes along, that we would perhaps update that and have some other suggestions as we go through. So annual leave planning is certainly something that we've been looking at with a number of clients. We can see, particularly given that the difficult financial circumstances many employers are facing, the financial benefit of utilising the furlough scheme to part pay or annual leave is a welcome relief for employers. I'm sure you're aware by now we don't just top up 20% of the furlough pay, because the furlough calculation is quite unique in itself. But if we are topping up, we top up to make sure that the employee on a day's holiday is receiving what they would normally have received when they were on holiday. If, like me, at the start of furlough, you were deferring bank holidays because we didn't know whether we were allowed to use furlough for holidays or not, if you haven't yet directed that those be used, I would certainly say you could consider that. And we have, I suppose, with a number of organisations, identified dates where we're writing out to employees who are on furlough to advise them well in advance that we're going to fix certain days in the coming weeks and months to essentially retake the days that we carried over from Easter. And indeed, for some folk, the May bank holidays, it's an opportunity to do that. But I suppose there's always balance to be struck, and I think it's very important that where possible, and from a proportionality point of view, we don't need to rush all of the annual leave into one stage. Staff do need time off later in the year, and I think there's a lot to be said for respecting the flexibility if people would like to take a family holiday later in the year. So there is certainly a proportionate way to look at this. The government guidance, understandably, is encouraging us to engage with staff and try and agree things where we can, and identify, I think, any periods where, if we're saying, look, if there's a period of time we anticipate you can't take holiday, it would be good to communicate that. And if looking at our work schedules at the minute, we think and we're satisfied that leave can be taken, that there should be really no requirement to carry over leave unless in exceptional circumstances, I would certainly encourage employers to be engaging with staff and communicating that, set the expectation and continue to review it, continue to engage, even if it's at the end of every quarter, to see what leave has been taken, and to encourage our line managers to have the confidence to get in there and have the conversations about, you haven't had any time off yet, or you've only had a day here and there. I'd like you to plan some time off in the next 3 months, please. If we can get it by agreement, obviously all the better. But if we can't, then ultimately we may have to consider providing notice. I put into this slide a couple of the government examples because I thought it was actually useful to see what the policy thinking was in some of the carryover examples. So one in the guide, one of the examples online, a worker has 2 weeks of holiday pay left and their leave year expires in 2 months. Owing to the coronavirus, a significant proportion of the workforce is unable to work during those 2 months. The employer assesses what steps it could reasonably take to manage the 2 month period, and it shows that it's not reasonably practicable for the worker to take both weeks in what is left of the worker's leave year. They agree that the worker will take 1 week in the remaining part of the leave year and that the other week will be carried forward to be taken as early as possible in the following year when the situation allows. And I suppose when I was reading that, my reflection certainly was it's a very hands-on approach, perhaps a more hands-on approach in discussing and agreeing leave usage than we might usually be used to. But so far, I have found most employees are very understanding of why the employer is trying to plan ahead and quite receptive to the necessity to do this. I have another example here. A worker has just started a new leave year and as such has their full leave entitlement to take over the next 12 months. Their employer experiences a significant short-term increase in demand that is anticipated to last for 3 months. The employer agrees with the worker that while it will not be practicable to take the holiday where demand has increased, it will be possible for the worker to utilise their full entitlement in the rest of the leave year, so there's no need to carry holiday forwards. And I suppose, again, confirmation about the importance of communication about when would be a busy time, that, to give people advance warning so that they're not disappointed that if they come to take 2 weeks off or whatever else, that request is likely to be declined. But I can see many conversations having to take place. In relation to carryover, which I think is probably the most interesting part of this and how this will develop in Northern Ireland in particular, the government guidance also gives the following example, which is useful. Owing to the coronavirus, a worker carries 2 weeks forward into their next leave year. In that leave year, they will have a total of 7.6 weeks of statutory holiday entitlement, which is huge when you think about it. The 2 weeks carried forward from the year before and the 5.6 weeks to which they're entitled in the new leave year. And in reality, most employees now have even more than that 5.6 weeks, so it's probably more than that. We're being told that the best practice is to allow the worker to take holiday from the entitlement that expires first. So workers should be allowed to take the holiday to which they're entitled in the new leave year, which seems a bit strange. So taking the 5.6 weeks before they take the 2 weeks carried over, as the carried over entitlement actually lasts longer. With the amendment to the working time regulations, that will actually last for 2 years. The regulations do say that when leave is carried over, essentially that the employee should be entitled to use it, and that there is a protection built in there. It would be interesting to see how it would work in practice, but the employer must have a good reason in refusing a worker's request to use carried over holiday. I mean, presumably genuine operational need should be objective justification in itself, but who knows? The employer may request that the worker takes both the carried holiday first, actually, instead of their regular entitlement in the next year. But if they do so, the employer must still ensure that the worker receives their full regular entitlement in the leave year to which it relates, in addition to any carried holiday pay. So where carried leave is carried into the next year, we must be able to facilitate taking both the carried leave and their 5.6 weeks entitlement. You can see how avoiding maybe a build-up and a carryover could avoid maybe some of the headaches carrying over into the following year, because you could see it being difficult to plan all of that usage, particularly for a lot of staff. And hopefully, if we only have those who really need to carry it over, if it's managed correctly, and we only have those who really need to carrying it over, it hopefully shouldn't be too much of an issue. So I thought I would work through an example with you this afternoon, and I thought this might be the easiest way when we're thinking about how we'll apply it in our own businesses. A worker has 35 days annual leave entitlement, and owing to coronavirus, they have only used 15 days leave this year, including their bank holidays. They have 20 days still untaken. The annual leave policy only allows up to 5 days carryover. How many days are they entitled to carry over? Do we think it's 20, 5, or 11.4? Well, the answer depends where you are on the map. We look at GB first of all. You'll all, I'm sure, be familiar with BEAR Scotland, but just focusing on the issue for now in relation to carryover. What BEAR Scotland on this particular issue said, it was for the employer to choose which type of leave is taken when. So what comes first? And in that case, they said it was absolutely fine for the employer to allocate the first 4 weeks as the working time directive leave entitlement, then the regulations, and then whatever was left under the contract. So applying BEAR Scotland as it does in GB, to my example, the worker has taken 15 days so far. So if the employer attributes the employee's working time directive entitlement to the start of the year, they have used 15 out of 20 days under their directive entitlement, and therefore they'll only need to carry over 5 days. So the answer in GB is B. The answer in Northern Ireland is C. Currently applying the PSNI and Agnew approach. I'm sure you've all heard of that one before, and the challenges that this case has presented in how we calculate holiday pay. But and I should say it is subject to appeal, and we'll talk about that. But applying it as it stands today, it is good law. It has been endorsed by the Court of Appeal here in Northern Ireland, our most senior court. And again, there's other aspects to that case, but for today's calculation, what the Court of Appeal confirmed that the 4 weeks leave under the Working Time Directive is not actually used up first, but it forms part of a composite whole. So they expressly deviated from BER Scotland, and they said it's not really for the employer to choose what type of leave is taken, and they thought that was a little bit artificial, and they said really employees don't allocate days, we don't really talk about it. Every day is just a mixture of those three components from one of my earlier slides. So what does that mean in practice, applying it to our example? So for a worker who has 35 days leave entitlement, as per our example, and you can amend this figure for your policies, each day of annual leave is made up of one of the following. 20/35 of that 1 day's leave is attributable to their rights under the directive. 8/35 of that day is attributable to their statutory rights under the Working Time Regulations, and 7/35 of that day is attributable to their rights under the additional rights under the Contract of Employment. Ridiculous but true. That is where we are at the moment. So if that employee has taken 15 days out of the 35-day entitlement, 20/35 of those 15 days relate to their leave entitlement under the directive. If I haven't fried your brains by now, I don't know. If we keep going through it, the penny hopefully will drop for us all. But 20/35 of 15 days is actually 8.6 days of the employee's entitlement under the Working Time Directive. So that is what they've used out of their 20 days. The same employee then has 20 days left to take. So I've just worked it out both ways so you can see how it pans out. 20/35 of those 20 days left relate to their leave entitlement under the directive. So we multiply that out for 20 days. They actually only have 11.4 days of their 20-day Working Time Directive entitlement left to take, and that is what they'll be entitled to carry over under the Working Time Amendment Regulations. Now, you might remember at the earlier slide I'd said the company had a policy that they would allow to carry over up to 5 days, and we are getting asked the question, well, is this in addition to that policy or is it included within it? I mean, I can only give you my best view or best guess because there is no authorities on these issues, but certainly my opinion would be that is within. So, you know, in this particular example, it's not 11.4 plus 5 days. The 5 days carryover allowance would be within the 11.4. So in this particular example, the employee would be entitled to carry over 11.4. Now, if I haven't confused you all by now, hopefully, but I'm hoping that those slides will be useful because you can just slot in, instead of the 35, slot in the total number of days that you provide in terms of annual leave, including your bank holidays for your staff, and it will give you a fairly easy calculation of what technically people are entitled to carry over in relation to their Working Time Directive rights, which is just the 4 weeks. It does seem ridiculous, and I actually do start to laugh when I'm talking about it because I just can't believe that this is what's required, and I can't imagine that even in terms of when Parliament's making the amendments and things like that, would anybody have imagined the impact of the Agnew decision? I suppose on that point, Agnew is subject to appeal. We know that case is going to the Supreme Court. I would be, I suppose, very surprised if it's dealt with in the next 12 to 18 months. So realistically, by the time the leave years come round, Agnew is still going to be good law, and I think there is a decision for employers in Northern Ireland. Do I just go back to my example earlier and apply the 5-day carryover, apply in BER Scotland? Or do I apply the Agnew Composite Whole composite fraction approach and allow the employee to carry over 11.4? I think with lockdown and everything else, I haven't really had a chance to talk to my peers outside Worthington's about it, but I am going to do so because I'm quite interested to hear other people's opinions on it. I haven't had any queries from trade union side yet in that regard, but certainly I suppose the issue is there, and there's a decision to be taken as to whether we apply Agnew as it stands at the moment, or we apply GB bar Scotland and see if anybody raises the issue with it. But it's certainly an unintended consequence of that particular case. And I suppose just going beyond furlough, in terms of my thoughts on holiday pay, I mean, I suppose like many things that we thought were extremely urgent and worrying before Corona, perhaps there's a certain amount of realism at this stage that yes, it's an issue. Annual leave as a problem still exists for us in Northern Ireland in terms of we don't have the 2-year back pay limit. We are still facing 98. And I suppose just to bring some clarity, because it's an issue we could talk about for hours, but I mean the law is absolutely clear back to Williams and British Airways. So 9 years worth of case law is clear at this stage that when workers are taking their 4 weeks leave entitlement under the Working Time Directive, they are entitled to be paid normal remuneration. So if you find that in your particular organisation, what people normally take home and what their basic salary is, if there's a material difference, a significant difference in those, I suppose there's a significant risk for the organisation of PR and bad PR and potential claims if we don't take steps to amend how we calculate our holiday pay. Now, I appreciate that there are policy decisions to be made as to whether we simply amend the calculation for the directive leave or whether we take the view that it's not worth the hassle of having a split calculation. We're going to apply a normal remuneration to all leave. But certainly, I know many clients will ask us, you know, we haven't done anything yet. Should we just wait it out and see what happens with the appeal? I mean, I would take the view that whilst you might to go down the road of back pay just yet, if you haven't began those sorts of discussions, I still think that the time is now to take steps to change how we calculate the Working Time Directive holiday if we haven't already done so, because that's not going to change as a result of the Agnew appeal. That is established law. The other aspects of Agnew in terms of pay reference periods, etc., may well change, but certainly the principle of normal remuneration is established. So I think it would be very important that we get our heads around that if we get the chance. And I suppose back to the other issue, I suppose, in terms of the difference between Northern Ireland and GB, we do feel that the law is diverging a little in this area, because for those of you operating in both jurisdictions, you'll be aware that there was a law change in April this year in GB that for employees who don't work regular or normal hours, there's a fixed pay reference period of 52 weeks when we're calculating holiday pay. Again, another change which we don't have here. We still have very grey area about what would be the appropriate pay reference period. And whilst it's up to the employer, I suppose, to try and engage, particularly if there's representation or trade union on staff side, to try and reach an agreement. Fundamentally, whatever we decide at the moment, it would be open to an employee potentially to dispute it and say, well, I want a different pay reference period. However, I would say that those claims are very few and far between. The claims that we see going into tribunal are the ones where the employer hasn't taken any steps to make a change in the difference. And the one point, I suppose, just to finish with, what I would say is if you're seeing commentary or about the Supreme Court appeal on Agnew, specific to the calculations I've just brought you through today, I think one of the most interesting points is if the Supreme Court were to overturn the Composite Whole fractional approach that the court has introduced for Northern Ireland. So when it turned its back on Bar Scotland and decided to do it this way, if the Supreme Court were to overturn that, that would be really interesting, because not only would we be back to the simple answer of carrying over 5 days leave, so simple, count what you've had and bring the rest back up to 20 in terms of carryover. It would be easy to calculate. It would reduce the risk and the level of carryover, as we can see the difference in days there, but it would also decrease the risk of a potentially significant back pay, because it might also break that series of deductions, because if our 4 weeks directive leave comes first, then the chances are that an employee will have been correctly paid their basic salary holiday pay for the regulation leave and the contract of employment additional leave in the latter part of the year. So that may also bring back this series of deductions point that might mean that the back pay wouldn't just be as far back as the law currently stands. I've probably melted your heads enough with that today. I have put my email address on the bottom. If anybody has any questions, I'm more than happy. But I do appreciate it can take a little bit of time to work through the figures.
Brilliant, thank you so much, Louise. I think we have a few questions in from some of the sessions today, so maybe I'll just field you 1 or 2 of those if that works okay for you.
Brilliant.
So we have a question that has come in. If staff have been furloughed as the business is closed and staff ask to take leave, but potentially there isn't the finances for this, can we ask for the employee to carry leave and refuse their leave request?
Yes, you can, because it wouldn't be a proper, for us to only pay 80% would essentially be an unlawful deduction from wages. And indeed, the government guidance online confirms that that would be a legitimate reason for the employer not to allow a leave request, i.e. that it wasn't in a position to financially afford the top up right now.
Fantastic, thank you. And a second question that we have is, can an employee sell annual leave if it is their contractual entitlement, not working time directive or working time regulation, as leave should be calculated as composite whole? Does this remove the option to sell holidays because part of it is the statutory holiday entitlement?
I think it would probably depend on your holiday policy. So if the provision is there for the employee to sell holidays back, they can certainly do it. I would have thought that the composite whole approach to fraction could still be applied, but I know that might not answer the query for that person. So if they want to email me the specifics of it, I'm happy to have a look.
Fantastic, thank you. Those are the only questions I've been at the moment. Have we got any other questions that we would like to put to Louise in this session? Just give people a moment or two to, oh, we have another one in. So, must notice to take holidays and furlough be given to the employee in writing?
I would say yes. It doesn't, the regulations don't stipulate it, that it must be in writing, but I would say absolutely put it in writing. In terms of creating a contemporaneous record, you would want to be sure to put it in an email, would be absolutely fine. Similarly, in terms of placing people on furlough, I know there's been a lot of confusion about what a furlough agreement might look like, but fundamentally there must be something in writing that goes from the employer to the employee, and the employee should signal their agreement, whether that's signed or just a return email to say that's fine and that we keep that for 5 years. But I certainly would give written notice of the requirement to take holidays. We have tried the gentle approach and the more firm approach, depending on the workforce. Sometimes we've said, look, we would like you to use 5 days across June and July, or we'd like you to use 2 days this month or whatever. And if the uptake on a gentle nudge hasn't worked, we've then moved to say, well, actually, we're now going to fix days. And provided we give double the notice of the time we're asking people to take, there's really nothing they can do about it. But I think there is a lot to be said for encouraging people to pick the days themselves first. But uptake has been slow with some staff who are maybe not just so much now in June, but certainly in May, when we were fixing days in May, I did come across an email from an employee who said that, quote unquote, she was locked in her house. How could she possibly take leave? And whilst I might not necessarily agree she was locked in her house, I can certainly understand her perspective. That how could she enjoy her holiday if she couldn't really go too far. But I suppose the rest and relaxation argument, I'm not sure that, provided we're only asking people to take a proportionate amount of leave, that we weren't, shoehorning their entire leave entitlement into the summer. Someone could challenge it as being contrary to the policy of the working time regulations. I've not encountered any grievances in this regard, and I think people understand that a certain amount of usage is common sense at this stage.
Fantastic, thank you. Another question that has come in is, can we end furlough if the employee turns down work or has got another job at the same time as leaving others on furlough if there is no work for them?
Yes, no issue with that.
Okay, fantastic. Well, that's my bank of questions that have come in. If anybody has any other ones, feel free to pop them in the Q&A box. But if not, as Louise has mentioned, she has got her details here on this slide. So please feel free to drop her a note if there's something pressing. And in addition to that, make sure and mark Thursday the 6th of August in your diary for our next employment law session, which will be led by Lisa Bryson from Evershed Sutherland. So pop that in your diary now, and we'll have it up online next week for you to book your place. Oh, we have another question in. We have another few in. Look, do we need to put in writing to an employee who is on furlough that a bank holiday must be taken during the furlough period, even if the bank holidays are set out prior to the furlough period?
No, you wouldn't need to do that. So let's say the 12th of July is coming up and the employee is currently on furlough. If they're going to be on furlough on the 12th of July, we previously notified them that was a fixed closure day for us. We just top that up when we're running payroll to make sure that they get a full day's holiday pay for that. So you're only going to have to notify them of any previous days that you've carried over, things like that. So no need to issue a written notice where you've already told them.
Fantastic. And then we have a question from Pauline about getting a copy of the slides and the calculator. I will absolutely send everyone a copy of the slides, which has a breakdown of the calculation in there that Louise has presented to us today. So I'll be sending that out post-session. So that is all of our questions. And Louise, thank you very much for taking the time today to present that session for us.
You're very welcome.
As I've mentioned, Louise is kindly going to create a blog for us. There's some content around this, which we will also put out next week. So until the next session, thank everyone for dialing in. Fantastic turnout today. And we will see you on the next session. So thank you all very much for your time. Thanks now. Bye-bye.
Bye.